Supreme Court strikes down Chevron and curtailing power of federal agencies. In a major ruling, the Supreme Court on Friday cut back sharply on the power of federal agencies to interpret the laws they administer, and ruled that the court should rely on their own interpretation of ambiguous laws. And the decision will likely have far-reaching effects across the country, from environmental regulation to healthcare costs. And by a vote of 6-3, the justices overruled their landmark 1984 decision in Chevron v. Natural Resources Defense Council, and which gave rise to the doctrine known as the Chevron doctrine. And under that doctrine, if Congress hasn't directly addressed the question at the center of a dispute, and the court was required to uphold the agency's interpretation of the status as long as it was reasonable. And but in a 35-page ruling by Chief Justice John Roberts, the justice rejected that doctrine and calling it fundamentally misguided. And Justice Elena Kagan dissented in an opinion joined by Justice Sonia Sotomayor and Jackson. And Kagan predicted that Friday ruling and will cause a massive shock to the legal system. And when the Supreme Court first issued its decision in the Chevron case more than 40 years ago, the decision was not necessarily regarded as a particularly consequential one. And but in the years since then, it became one of the most important ruling on federal administrative law, cited by federal courts more than 18,000 times. And also the Chevron decision, which upheld the legal and environmental protection agencies' interpretation of the Clean Air Act that eased regulation of emissions, and was generally held by conservative at the time. And the ruling, by the way, eventually became a target for those seeking to curtail the administrative state, and argued that courts, and rather than federal agencies, and should say what the law means. And the justice and rebuffed earlier requests, including by one of the same lawyers, and argued one of the cases here. And to consider overruling Chevron before they agreed, by the way, last year to take up a pair of challenges to a rule issued by the National Marine Fisheries Service. And the agency had required the herring industry to pay for the costs, and estimated at $710 per day, and associated with carrying observers on board their vessels to collect data about their catches and monitor for overfishing. And the agency, by the way, stopped the monitoring in 2023 because of a lack of funding. And while the program was in effect, the agency, by the way, reimbursed fishermen for the costs of the observers. And after two federal courts of appeals rebuffed challenges to the rules, and two sets of commercial fishing companies came to the Supreme Court asking the justice to weigh in. And the justice took up their appeals and agreeing to address only the Chevron question in Relentless v. Department of Commerce and Labor Pride Enterprise v. Remendo. And Justice Ketanji Brown Jackson dissented in the Relentless case, but was recused, by the way, from the Labor Pride case, and presumably because she had heard oral argument in the case while she was still a judge on the U.S. Court of Appeals for the District of Columbia. And the Chevron difference, Robert explained in his opinion for the court on Friday, and inconsistent with the Administrative Procedure Act and the federal law that sets out the procedures that federal agencies must follow, as well as instructions for courts to review actions by those agencies. And the ABA Roberts noted that agency interpretations of status and like agency interpretations of the Constitution and are not entitled to deference. And under the ABA, Roberts concluded it thus remains the responsibility of the court to decide whether the law means what the agency says. And Roberts, by the way, rejected any suggestions that agencies rather than courts are better suited to determine what ambiguities in a federal law might mean. And even when those ambiguities, by the way, involve technical or scientific questions that fall within an agency area of expertise. And Roberts, by the way, emphasizes that and Congress expects courts to handle technical statutory questions, and the courts also have the benefit of briefing from the parties and friends of the court